The offence of corporate manslaughter will be committed when the way in which a company manages or organises its activities causes a death, and that death amounts to a gross breach of duty of care owed by the company to the victim. The Act is so important because it certainly makes much more likely the prospect of prosecution for manslaughter than under the existing law, and it is designed to be tougher than health and safety legislation in terms of sanctions. There's been a clamour for a new offence, I think, for a good many years. It's because of the difficulty of prosecuting corporations under the existing law, where you had to show that there was a controlling mind, someone at the controlling mind, so strategic level of the company, who had been grossly negligent. And with large organisations, evidently that was virtually impossible. And so there were a whole catalogue of prosecutions which failed simply because the prosecution couldn't prove to the correct evidential standard that someone at the strategic level, controlling mind of the company, had been grossly negligent, and that had been causative of the disaster and the deaths. There is also the inherent unfairness of the existing law, in that it's much easier to prosecute a small company where the controlling mind, the managing director, for example, might actually be involved in the work activities. And a good example was the Lyme Bay canoe disaster a few years ago. It was his direct failing which led to the death. Well, it was his decision to allow the children to put to sea in the canoes. He was grossly negligent. He was prosecuted of manslaughter personally, but the company was convicted of corporate manslaughter. The penalties will be substantial. The Act provides for unlimited fines to be imposed. The recommendation from the Sentencing Advisory Panel is that the starting point should be 5% of turnover. Investigations will be carried out by the police, but inevitably with the assistance of the Health and Safety Executive. In order to avoid prosecutions for corporate manslaughter, companies are going to have to make sure that they are following the highest possible standards in terms of health and safety management and risk assessment. It's important to companies not just to have systems in place, but to enforce them. If they don't have those standards, then they are vulnerable to prosecution under the new legislation. Juries will be looking at an organisation to see whether there is any tolerance of bad practice and whether there is a health and safety culture within an organisation, or whether it's simply paying lip service to it. So that's a new concept in legislation. I think that's really the biggest challenge for industry to meet in preparing for this new legislation. Companies really need now to be looking at their existing health and safety management systems. So in terms of employees, have they had proper training? Have they had sufficient training? Are they complying with health and safety instruction? If not, don't be afraid to use a disciplinary process, because you'll be able to demonstrate then that you're not just paying lip service, you're actually trying to enforce the system. Contractors is another area which needs very careful management. You've got to make sure that any contractors you use have the same health and safety standards as you, so that means prior to appointing them, you need to check their health and safety records, make sure they're understanding of your requirements and that they are devoting sufficient resources to health and safety. If you don't lead from the top and make sure that you have a clear understanding of health and safety responsibilities throughout an organisation, it's going to be very difficult, if under investigation, to show that you have this health and safety culture, which is really at the nub of the new legislation.